Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today is Tuesday at 10 a.m., and we're back here on the Bottled Business Sense show for another great episode. Welcome to all our returning viewers and listeners out there, and if you are new, welcome. We are a best practices simulcast show that shares in marketing best protections as well as legal best practices to properly protect your business as well as protecting your assets. Bill's going to talk a little bit today more on the employment side. But before we get to that topic, I want to welcome everyone out there and reach out to us on social media. We welcome your comments, your feedback on the show. You can find us on Facebook, Twitter, and Google+. And if you would like to be a guest on one of our episodes here, why don't you go ahead and send us an email about your topic, a little bit about your background, and you can send that to bottledbusinesssenseshow@gmail.com, and we will take a look at it and hopefully have you as a guest on the show. So with that being said, I want to welcome Mr. Bill Bernard, our legal expert on the other side, to the show. How are you doing today, Bill?
I'm doing fine, Rick. Thank you. Good to see and hear, everybody that enjoys our show and that comes to us for some free advice. Remember, our show is geared toward giving everybody some general principles, whether it be in the area of law or marketing, and is not strictly applicable to your own personal situation. You take from it what you think is applicable. And I always urge everybody to call an expert in the field to ensure that some of these principles can be applied correctly to their own business situation, so that they are not behind the eight ball and that they fully understand how some of these principles that we discuss can be directly personalized to their specific situation. Having said all of that, we discuss from the legal aspect of things, employment law, we discuss asset and estate protection planning principles. All of the things I think go hand in hand in running a business and making sure it's prosperous and also safe and protected. So today, I'm going to discuss very briefly, it's a very short show, I'm going to discuss a topic that was brought up by one of my clients, and he asked the question, can I go ahead and just bring somebody in as an intern in my business and not pay them? And, of course, I had to kind of just smile within myself because I thought at first, well, maybe this is a situation where you're trying to get away with some, shenanigans, or maybe it's really on the up and up. This wasn't a client that I knew very long, so I really didn't have a solid read on what he wanted to do. So we proceeded to ask a lot of questions, and basically it led to this show, which is what's the difference or the distinction from a general standpoint between an intern and an employee. And we sat down and started to explore this, and we really, I led off with the general premise that an intern is not someone you simply select to work for you and not pay. Well, I'm going to call you an intern and not pay you. Working for you, they are an employee, and the labor code will apply in all respects. You'll have a duty, in other words, to pay this person at least the minimum wage for all hours he or she works for you. The labor code in California does provide an exception that allows true interns or externs to come into your place of business and perform tasks without pay. But that is related, those rules are related to the fact that the exception is required that an internship be part of an established union or educational institution. First ingredient. So if someone is going to come in and want to do an internship for you, they're going to have to be part of an established union, or they're going to have to be part of an educational institution program where they are going to do an internship for you in order to learn and benefit from the expertise you're going to provide them in the field that they are studying. And that's most often where you see an internship. I don't know, you've never come across in your business any interns,
well,
I'm
yeah,
assuming, right?
like a summer internship where they're in between, they're on summer break and they want to get some experience. Absolutely. I mean, I get requests like that all the time. I've never had an instance where I needed to bring somebody on like that, but certainly have considered it in certain projects. I can say, for instance, my daughter, who is in college and is looking to do a summer internship, she'll probably be going through that process. Not sure if it's a paid position or not, but I've always been curious on the legal ramifications and how that's classified.
Well, typically internships are not paid, and that's why people who really aren't in tune with this say exactly what this client of mine approached me about, and that is, can I hire somebody as an intern and not pay them? Well, that's a contradiction in terms. You don't hire an intern. An intern comes in and does work for you without pay, and there's three principal ingredients involved. One we just discussed. Must be a member of an established union or educational institutional internship program. That's number one. Number two, the intern cannot perform work that replaces the work that a paid employee would otherwise perform. Okay? They can't come in and have knowledge of everything you're doing and then replace an employee. They're coming in to learn from you about things that they don't know much about. That's the whole purpose of an educational internship, right? Mm-hmm. It would be the intern, if the intern is performing duties that are primarily benefit the intern and not the business, then it's okay. So what the intern must be doing is something that benefits them, providing them that education that they need, rather than just benefiting your business. If they're coming in and you call them an intern and they're not getting anything out of it and they're benefiting your business and your business only, in other words, you have really an employee that you're not paying, well, then that's not an intern. So that's really, really critical stuff that you need to know. Your intention to bring on free labor because you cannot afford it or you simply don't want to pay the person will expose you to an audit by the Labor Commissioner's Office, the California State EDD Department, and liability to any intern who worked for you up to 4 years after they leave your employ. So imagine paying penalties for 4 years to the intern because they weren't really an intern, but rather an employee. If you don't classify them correctly, the California State Department of the Labor Commissioner's Office will come down on you pretty quickly because they don't like that sort of stuff. And remember, you can't just call somebody an intern because you simply want to. They have to fulfill certain criteria and qualifications before you can utilize that function. It's no different than if you classify someone as an independent contractor and they're really an employee. That's the same idea, so to speak, because you then will incur many penalties and fees and fines from the misclassification.
So based on your description, what you provided here, give us an example. Let's say you in your law practice takes on an intern. What would you have them do, or let's say it's a summer. They're in between, spring semester and fall.
No, I got you. They come in for an internship, and the legal internship would be set up to where they would want to learn how to write perhaps client letters or certain motions or certain briefs. And they want some expertise on how to do that better, which will benefit their legal writing in school, but which is not going to just benefit my business, but benefit them as well. They can come in and apply for a legal internship whereby they will be my intern for a certain period of time. We're way past the years of slavery. This can't be a slave you bring in. There's going to have to be some relationship to their education. You have somebody come in and they're gaining some knowledge from performing tasks that they will benefit from. Now, that's not to say that your business can't benefit too, because after all, I'll be getting things done that they will be helping me with, probably not as quickly as if I had a full-fledged law clerk or experienced paralegal doing it. But the key distinction is that you have to have the benefit of what they're performing to be primarily for them and not for your business. So if it's primarily being done only to benefit your business, and if it's solely being done only to benefit your business, then there's no interest in the intern. The intern doesn't gain anything, and so therefore it's really not an internship. It's really an employee-employer relationship, and boy, you could be taken to task for something like that.
So then, with that being said, give us an example of how somebody would, or how this would be disclosed if you went outside of the boundaries of someone actually being an intern.
And applies for a law clerk position. Somebody is now after finishes their second year of law school, and they say, Mr. Bernard, can I be your law clerk in order to perform certain legal functions that, yes, will benefit my education, but that are primarily going to benefit your business as well, because I don't need to learn this stuff from the inside out. I already have a working base or a working knowledge of it, and I want to be paid for it. That's going to be an employee situation, not an internship, because the internship, remember, let's go over this again, it's important. It has to be by way of an educational institution, through an institution, right? So the institution, I'm not making contact with this person through the educational institution. This person is applying for a job from me and may go to some institution that I'm not affiliated with, associated with, or have no knowledge of. Second, this person would be replacing or taking part in an employment opening that I have. Okay, so they would be stepping in the door as an employee, doing work for me as an employee, and performing duties that primarily the business as much as the individual who's coming to work for me. So it's a fine distinction at some levels, but you have to be very, very careful, because the internship is usually set up through the union or the school. In other words, they're sponsoring, or they're putting you in touch with somebody for the specific and strict purpose of being an intern, not somebody who's coming through the door and applying for a job. So you need to be very careful of that. And I would also mention that if you fail to cover these persons who are really employees with workers' compensation insurance as mandated by California law, and someone gets hurt, boy, you face penalties in the 5 figures, expenses and other losses experienced by the employee when you're calling them an internship and calling them an intern and not covering them with workers' compensation insurance. So that's another little feature that people need to grasp onto. So if you have any doubt as to whether somebody's an intern, specifically have them fill out some forms that would indicate what the purpose of their relationship with you is going to be. And a lot of times that can be gained or gotten from the educational institution. And find something that indicates to them that the understanding is that this will be an internship that will primarily benefit their learning experience, and that they are doing this in order to fulfill some of the obligations they have with the university. Many interns, Rick, get credits. So you have a legal intern, they come in and they get credits, so they're rewarded by the school for having the internship. If you many times go and see law clerks or paralegals who are working for an attorney, they're not getting credits for doing that. Most oftentimes, they're getting paid. They're getting money. Mm-hmm. Yeah, they're getting the experience, but they're getting paid because they're an employee. They're not somebody who's coming in to fulfill some sort of a credit mandate for the university or the union that they belong to. So it's a very.
Let me ask you this: is it an oxymoron then when somebody says, "I have," and we're doing this through the university that we have a paid internship available? What is there any play on words there that makes it confusing? Or
well, you mean when somebody will come to you and say, "Yeah, I have a paid internship." Well, that seems to be a contradiction in terms, because a lot of times the paid portion of that will be through the payment of credits, if you will, that they will get from the institution for doing so. There will be very, very. I can't think of any time off the top of my head where someone is paid as an intern. That's a complete contradiction between employee and internship. Remember some of these things too. The internship, even though it includes actual operation of facilities of the employer, is similar to training which would be given in an educational environment. The experience is for the benefit of the intern. The intern does not displace regular employees. That's really a critical advantage. In other words, if you have an intern who says, "I want to be paid," well, then that's one less employee that you need. And if you're paying that intern, then that intern really becomes, in my opinion, an employee and not an intern. The intern is not necessarily entitled to a job at the conclusion of the internship. That's another critical aspect. Many times you have law clerks or paralegals come in, and at the end of their time training with you, they apply for a job when they pass the California bar examination. That's not the case with an intern. It's not something that an intern typically bargains for when they enter the relationship. Understanding is that the intern is not entitled to wages for the time spent during the internship at in the employment atmosphere. That's got to be the critical understanding. And it should always be remembered that the outcome of the internship program should be solely based on the training of the intern according to a predefined curriculum, Rick. So in other words, you're going to have an institution providing you with a curriculum that says, as part of this curriculum, as part of this scenario, we want this person to have the benefit of your training in order to fulfill critical mandates in his educational program. So that's really where a clear distinction lies, and where the distinction or the line can be drawn. If you want to get right down to the nuts and bolts of it. And, some other things that might be important to mention is, the company that's providing training is really not dependent upon any other factor. So what do we mean by that, if we want to sum this up? It's not dependent on a future job. It's not dependent upon being working there for any length of time like an employee would, right? Which means it's not connected to wages. It's not intertwined or dependent upon anything that the business is doing. It's solely designed to help learn through an educational curriculum that the intern is participating in. So if you come to me for a job, Rick, off the street, and you say, "Hey, what can I do for you, Bill? And I say, well, I'll tell you what, I could use a lot of help, Rick, and here's what you can do, but I'm going to call you an intern. You can be my intern. I'll teach you some legal principles along the way, but you have no desire to go to law school. You're not a law clerk. You're not a paralegal. You're not in law school. And I start having you work for nothing. You're an employee, and I could be severely fined as a result of misclassifying you. So I hope that's some principles that some of our viewers keep in mind. I know it's a short and succinct show today, but I think it's something that's worth do.
Yeah, absolutely. One general question then, Bill, is that a blanket classification then, regardless of where you are in the states, or is that does it differ depending upon the state?
Well, every state is going to have different sets of rules in terms of the fines and the penalties you pay, but internship is generally well known to have the same basic foundational principles. What the fines would be in the state of Tennessee versus what they would be in California versus because of a misclassification is something I don't have any knowledge of, because I'm concerned with California employers. But let me end the show by giving a suggested approach for how a intern program might work, where someone is actually paid, because you mentioned paid internships, I believe, earlier, Rick. A company agrees to hire an individual for a definitive period of time, with clearly identified starting and end dates, and the company pays the individual minimum wage or more and creates a structured program that will benefit the intern and the company. So what do I mean by that? Goes back to what I said earlier in the show. At the point in time that intern comes in, you better be sure that person is connected with a program, that the person has well-defined functions and understands that he or she is not going to be paid. A paid intern program would be somebody for a definitive period of time, and that they're not classified as having to fulfill any specific program that they may be affiliated with. So why is that worth mentioning on the show? Because in my opinion, that hiring of a person for that designated period of time makes that person an employee, and therefore negates any paid internship program that people might want to call it. I don't really believe in a paid internship program. I believe that if you're paying for somebody, you're doing it for the benefit of your company, and you're doing it whether it's for a lengthy period of time or a definitive set period of time. So be aware of that stuff, and talk to a lawyer if you're at all confused about it. But remember, there are certain critical foundational items that you need to fulfill before you start calling somebody an intern. And those main ones are the benefit for the intern, the association with some program that benefits them educationally, and the fact that they're not replacing an employee in working in the position that you've got them working in.
Awesome. Well, great. Bill, thanks again for educating our viewers and listeners out there. As always, appreciate the insight and look into this topic. Folks, if you have any questions or on this topic, or are in help of some more employment law knowledge, please reach out to Bill, and Bill will provide his email and phone number contact for everyone out there should you want to reach out to him.
Yep. It's 949 area code, both numbers, 698-6222 and 413-6535, Bill at wfblegalconsulting.com. And we're all over the place. I mean, if you Google my business, you'll find us on every fathomable social media site, and also my website as well. So, I think you can get in touch with us through the show on bottlebusinesssense.com, right, Rick?
Yeah, absolutely. So reach out to us if you have any questions. Reach out to Bill at the contact information he just provided. It's also below this video and audio on our website. And as always, Bill, thank you again for your expertise. folks, we will look forward to seeing you on the next episode here coming up in a couple of weeks. On behalf of myself and Bill, we thank you for joining us this week on the Bottle Business Sense Show. Take care. Have a prosperous week, and we will see you again on the next episode.
Take care, everybody.